page 3.5, you kick off by saying your affidavit, by saying it is stated that the suspects fled on foot and the hat which was worn by the shooter was left on the crime scene.
That is correct, my lord. I see that.
Abasola babaleka ngezinyawo kodwa bebaleka isigqoko esasigqokwe omunye wabasola sawela phansi.
You further said that the incident took place between on paragraph 4 of this affidavit. The incident took place between 8:30 and 9 o'clock in the evening, and the deceased was declared dead on arrival at the hospital at 9:15 in the evening. Is that what you say?
Isahlalo lesisenze phakathi kwamahora ka-8:30 no-9 wasebusuku nokuthi bafike esibhedlela ngo-9:15 akunjalo?
Yes, my lord, that's what I'm saying. Even the top part of the head being left at the crime scene, it's correct. It's contained in the docket. The declaration of the deceased, when they were declaring him dead at 21:15, it's in the docket. That is correct, my lord. And the estimation, because this 9:30, and it appears in numerous times in my statements, that is between 20:30 and 2100 hours, because you have to take into account and that's what is contained in the docket, my lord.
Yebo unjalo ngoba bafika nesibhedlela basho ukuthi ushonile ngo-9:15 bathi ukuthi ushonile. Yebo lamahora abenjalo ngoba kwavela ukuthi cha kwakuyizo lezo zikhathi ka-8:30 no-9 wasebusuku.
Now you go on, you proceed in paragraph number 4. Paragraph number 4, subparagraph 2 thereof says, investigation which resulted in evidence under oath revealed that the victim was murdered in a contractual assassination or hit rather than a robbery or a robbery gone wrong.
La ngiyachaza ukuthi umufi lo wabulawa ngabaqashi ukuthi bambulala nokuthi kwakungekona ukuthi wadubuleka ngesikhathi beza ukubamba inkunzi.
Yes, that's what I said, my lord.
Yeah, we're going to share.
And is this the evidence that you had when you applied for this, when you wrote this affidavit in application for in preparation for the 205 application?
Well, you know about ngesikhathi ubhala ke le affidavit faka isicelo se-205.
Indeed, my lord. Yes, I had this application because if you look at the commissioning date, it's dated 2020 December 07. The accused were already arraigned even that time. They already made their first appearance in Boxburg.
Yeah, kunjalo ngoba uyabona lo suku olubhaliwe lapha ukuthi abasolwa abasisebeboshiwe sebeyovela enkantolo eBoxburg.
So you basically are saying to the magistrate that no, this was a contractual killing. It was actually not a robbery or a robbery gone wrong, as the office of the DPP has mentioned in their summary of substantial facts. Not so.
We were going to rise for the last time on this aspect, and you know we don't want to interfere with Adv MNISI's cross-examination, but we submit with the greatest of respect that we're splitting hairs here. I think this line of cross-examination, and we say this with the greatest of respect, demonstrate a fundamental misconception of Section 205. Section 205, it's aimed at actually states on there are two jurisdictional aspects regarding Section 205. Firstly, there has to be evidence that an offense has been committed, and secondly, that the person who's been subpoenaed has got that information. So those are the only two jurisdictional aspects that trigger Section 205, namely that an offense has to be committed. The affidavit says that an offense has been committed, and secondly, that the person, the service provider, is in possession of that information. Cell phone records are required to determine if what in or Section 205 records, cell phone records are needed to determine what role any cell phone communication played. This is not a trial before a magistrate. The magistrate is not required to as it were, is not a trial of fact. All that the magistrate needs to convince himself are those two jurisdictional aspects, that an offense has been committed and the person from whom the information is required is in possession of that information. That can help to resolve the crime in question. Those are the only requirements of the section. What my learned friend is busy with, my lord, will be absolutely...
I'm at no point, not even with a bit of an inch, am I challenging the validity of this Section 205. That is not my aim, and I will never do that. However, it should be borne in mind, my lord, that this Section 205 is based on certain information that the magistrate is being provided with, which information stems from the investigation that is contained in the case docket. Unless my colleague says to me he's not feeling comfortable when I'm raising what is contained in this affidavit, which is accompanying. It's an application. How can I put it? This is an affidavit in support of the application of the Section 205. Unless my colleague is saying that I should not actually question this affidavit because as is, it is as is. But it is not as is, vis-a-vis what this witness testified about in his evidence. Remember, he is the same witness, my lord, who penned this statement, this affidavit under oath, which facts he got from his investigation. So there's therefore nothing wrong with me when I take him through what he presented to the magistrate, which is exclusively based on the nature of his investigation. I'm not challenging the validity of the Section 205.
So what are we about if you're not challenging the validity of the information which was acquired?
Contradictions. I'm about contradictions.
What type of contradictions?
Contradictions that will enable the court later on to decide whether he's a credible witness or not.
Yes, sir.
Yes, my lord.
Yes, sir.
Thank you, sir. Now, you are saying in your affidavit that the evidence which you heard under oath revealed that the victim was murdered in a contractual assassination or a hit rather than a robbery which has gone wrong. Now, before you answer, let me complete my question. Are you aware that what we have just said here totally contradicts the summary of substantial facts that are contained in the indictment? That you are saying this was a hit when the summary of substantial facts are saying that this is a robbery that went wrong. And in fact, you are saying, sir, it was a hit and not a robbery which has gone wrong. Do you see that?
Well, again, my lord, we want to rise on a different aspect, and we'll find authority to this aspect that the motive for the commission of an offense need not be disclosed by the state in the formulation of the charges. So whatever the motive was for the commission of the offense is irrelevant. If someone has been murdered, what the motive thereof was, my lord, is absolutely irrelevant. The fact of the matter is that murder was committed. We submit, therefore, that what my learned friend is trying to elicit from these witnesses, it's not in keeping what the law says. It says motive for the commission of an offense is irrelevant.
This is the call, my lord. Again, I submit, my lord. There is a dire misunderstanding of the Criminal Law Amendment Act. What is that act now that deals with the minimum sentences? The Criminal Law Amendment Act 105 of 1997. Yes, that act is very specific, my lord. And subsequent to that act, so many authorities have come. And if my colleague says that in the indictment you don't need to put a motive, as I'm saying, it's a misunderstanding of the law, my lord, because you need to put in the indictment information that will enable the accused to plead thereto, to enable him to conduct his defense in terms of what the charge sheet says. But nonetheless, my lord, I'm not talking motive here in my cross-examination. I am simply bringing it to the attention of this witness that is he then aware that what he's telling this magistrate, he's saying to the magistrate, look, this was a contractual assassination. He has said he does not know why Kelly would have wanted to kill SENZO because he has not investigated that. But all that he knows is that this was a contractual assassination. But the summary of the substantial facts are saying this is robbery or a robbery which has gone wrong. Now I am saying to you, are you then aware that you basically negating what the summary of substantial facts contain when you say, no, this was not a robbery or a robbery which has gone wrong, but it was a contractual killing? Is he aware that he basically negates what is contained in the indictment? That's all that I'm asking him. I'm not talking motive. I also don't know why SENZO was killed. He also has said that he does not know why SENZO was killed. Contradictions. Thank you, man.
My lord, I'm not sure. Should I answer? Should I respond? I don't know. My lord, look, if I have to comment, firstly, to say or to make an assertion that this statement A333 contradicts what I've said in my evidence in chief is not correct, because it is in line with what I've said. That's number one.
Sorry, just to correct, I am not saying it contradicts your evidence in chief. I say it contradicts what is contained in the summary of substantial fact in the indictment, not you.
Oh, I thought it was directed to me.
No,
Okay. All right.
it was not directed to you.
All right, okay,
Yes.
then I misunderstood. My apologies. Secondly, my lord, the issue of the paragraph, the one that deals with the contractual killing rather than the robbery gone wrong. I think it's in... just want to find it, my lord. But basically, the paragraph that refers to... No, let me just put it. Let me
Oh, you
just
want
deal
to
with
finish
it.
it?
Yeah, let me
Okay,
just
that's
deal
fine.
with it. It will be short, my lord. What I'm saying, my lord, is that the paragraph that refers to the incident being a hit rather than a robbery gone wrong. I also dealt with it, my lord, when I applied for the warrant of arrest of the accused. And the application for the J50 is dated 23 August 2020. This is before the warrants were authorized. So it is not a new thing. I've dealt with it right from the beginning, going upwards. I've never kept that part away. And that is because the investigation revealed such evidence. So it is not for me, my lord, to take left when evidence is pointing me to right. That's the second part. And thirdly, and I've said this, my lord, I cannot speak on behalf of the NPA. I think the powers, they are clearly separated. And I'm not the one who can answer to that. I can only account to what was contained in the docket and what I presented to the magistrate. Now, if I had went to this magistrate in Johannesburg and presented facts which are different to what is contained in the docket, that would have been a crime, my lord. I could not say when evidence sitting before me indicates that this was a contractual killing, then I say something else. This was based on what is contained on the docket, and I presented these facts as they are. That's the truth, my lord.
Thank you, my lord.
Family, I'm back again on the same case of SENZO. This is the family channel. Have you subscribed, family? Please don't forget to subscribe. Give me good Christmas holiday by subscribing, liking. Just go, it's just free. You just press the like button, subscribe. That would be a very good Christmas present for me. So family, today I just want to talk about how MNISI exposed BALOI as to why Kelly was not charged. This, when you watch this video, you see that BALOI was never comfortable at all the way he has been exposed by MNISI. Adv MNISI took a long run before he came to the point to expose them, because he was trying to put everything together, even though the judge tried to object and do whatever. But MNISI kept his cool. They read the rules and the laws that are in the big books of law, even though MNISI kept his cool. This is where you see BALOI not comfortable, because he was part of the game, whereby he decided not to charge Kelly Khumalo in this case as accused number 6. Because you cannot have this accused but you have kingpin. What is going to be their response? Because the kingpin sent them, but the kingpin is not in the dock. So who are they going to point fingers to? As to, hey, we are in this problem because of ABC. But what Advocate BALOI did, he tried to hide the truth, knowing very well that those 5 accused were not in the scene of crime, but he wanted to use them as a scapegoat. Because in the indictment, there is nowhere where it says Kelly was mastermind or kingpin. It's either they put him as a complainant or as a witness. What is that? Because on the indictment, it should have been stated, even if she is not arrested, but it should have been stated, because the defense could have brought it in court and say, what are we doing here? Because the mastermind is... But in the indictment sheet, there was nothing like that. But on GININDA's affidavit and statements, it shows that Kelly was supposed to be indicted, but he decided not to do, because they say it was a contextual assassination. Kingpin was Kelly Khumalo, as far as what Brigadier is saying. In his own affidavit, in his statements, he is saying that. But to our surprise, Kelly is not within the 5 accused there. So that is the biggest fight that we saw BALOI up and down objecting, just for MNISI not to expose the lies that implicate him, BALOI. Because BALOI, looking at all what he's doing in this video, it shows that he was part of the cooking. And he was part of the people who said Kelly shouldn't be arrested. Let's keep our cool and keep, like, we are investigating. For how many years? How can they push these guys to be arrested? But Kelly as a kingpin or mastermind and is outside. And BALOI is busy objecting in this video to show that he has no case against these people. They're just wasting their time. Instead of bringing the people who were in the house and arrest them, and one by one they will start to expose each other, how they cooked the evidence that is in that court. Who was the mastermind of doing that? We will all know the day the church people were in the house. What do you think about what BALOI has been doing up and down here, trying to defend himself? Just drop your comment. Because he didn't want some... When Advocate MNISI wanted to read the indictment, BALOI was opposed to that. And even the judge helped on that. But they were never successful, because MNISI put his foot down that I'm not moving an inch on this question. I need to get answers. And it's what he got. So it is simple and straightforward that BALOI was part of this manufacturing this kind of case and arresting the wrong people. What do you think, family? Do you think MNISI did us proud on this one? He's always doing us proud. When he stands up, he stands for his clients. He never give up, and he never give up. He keep his cool, and he hammers, exposing the whole shenanigan that is going on in court. Family, don't forget to like, share, and subscribe. I want to wish each and everybody who will come across this video a Merry Christmas. And to all YouTubers, let us go and revisit all what has been going on in court and analyze it the way we feel the loopholes are there, so that we can keep exposing this. Because if we keep our cool and keep our heads down now and not continue to do this, when they come back on the 20th, they will think we have forgotten everything. But if we keep this fire burning, as they continue having holidays watching the YouTube, because they watch each and everybody who's exposing this case. So let's not forget to keep the candle burning, because it will help. We are not saying the same thing. We analyze this case differently. As much as we analyze this case differently, let's not forget that if we keep doing it when people have time during their holidays watching YouTube, they get to understand what is happening in court. Don't think about, oh, the court is not going on as a YouTuber. Just go and revisit. Because some of the things we skip them. When you go back, you realize, oh, this, I didn't talk about it. Then you go talk about it, because it will help. Because Rome was not built in one day. One brought a brick, other one brought zinc, other one brought a plaster, other one brought sand. A lot of people built Rome until Rome was what it was. So let's build everything we can do so that we expose all this kind of shenanigan going on. For the people who are not aware, who will come across those videos, it will help. Ngiyandithanda nonke my YouTubers. Let's keep exposing until we get SENZO Mayiwa's deleters. Once we get those people who deleted his life, the family will get closure. Sithi uSenzo akalalanga ukucinga amadolo. He is fighting to get them arrested. Bravo, bravo, bravo.